The following program is made possible in part by the Dayton Bar Association.
Hello and welcome to You and the Law. I'm Mike Monta, your producer and host for tonight's program. And as we approach the holiday season, we can expect parties and possibly drinking and possibly driving and possibly a combination. So our topic for tonight is going to be drunk driving laws and things related to that. Joining me as guests, expert guests on our program tonight are the Honorable Fred W. Dressel from the Kettering Municipal Court, Mr. Matt Kourtjohn, who is Assistant Prosecutor with the City of Dayton, Ohio, and the eminent Mr. Charles M. Rowland, who is a specialist in the DUI area of the law. And we'll be talking to them tonight. Before we get to our panel discussion, let me remind you that You and the Law is a monthly presentation produced here at the studios of the Dayton Access Television. DATV is on Channel 5 of the Time Warner Cable Network, and we also cablecast on tape delay, and in the outlying areas we're on Channel 6, I believe, and we also stream live at datv.org. The executive producer for the program is the originator of this show, former domestic relations judge Mike Brigner, and maybe Mike's watching tonight and will call in. This is an audience participation program, and occasionally you will see the number to call in, which is 223, and there it is, 223-5311. And we welcome your calls about tonight's topic, and our experts will tell you all about it. Let me, and we're sponsored, as you saw at the beginning, by the Dayton Bar Association. We'll talk a little bit about them as the evening goes on. So let me turn to our guests. We'll have them introduce themselves to you a little more fully, tell you about their familiarity and background regarding this subject. And we'll turn first to our friend, the Honorable Fred Dressel.
Thank you, Mike.
You're welcome.
I'm Fred Dressel. I was appointed to the Kettering Municipal Court in April of 2014, and then was elected in November of 2015. Before that, I was in private practice for a little over 20 years, and before being in private practice, I was with the Montgomery County Public Defender's Office for about 6 years. And during both private practice and as a public defender, I handled a fair amount of OVI cases, and in municipal court, we see quite a few OVI cases.
Thank you. Great to have you with us. And we'll turn now to the prosecutor who has volunteered to come to our show tonight from the City of Dayton, Mr. Matt Kourtjohn. Welcome, Matt.
Thank you, Mike. Yeah, I'm an assistant prosecutor with the City of Dayton Prosecutor's Office. I've been with our office for about 8 years now. The City of Dayton Prosecutor's Office is responsible for prosecuting all misdemeanors that occur within the City of Dayton, and a large percentage of what we do are OVI cases. OVI cases will be up to a point a misdemeanor offense, so it's something that we are required to know a lot about. I will occasionally prosecute cases in other jurisdictions as a special prosecutor, and I've been certified or I've received NHTSA certification to be able to do field sobriety testing. It's something that we use as part of our practice as prosecutors.
Great. Thank you, Matt. Good to have you with us. And turning lastly but not leastly to Mr. Charles Rowland, defense attorney. You only do DUI defenses.
My tagline is all I do is DUI defense. I've been an attorney for 21 years. To become proficient in DUI, I have obtained certification in the field sobriety testing. I've trained as a drug recognition expert. Twice a year I teach at the police academy where we do a mock trial to help cadets learn how to do this the right way. Everything I do is about DUI, and I think that I try to raise the bar a little and do it very well.
Good, great to have you with us. And let's start off by talking about what DUI is and why do we have it and what's it good for and things like that, legally speaking. Judge Dressel.
Well, it's been against the law to drive under the influence of alcohol for many, many, many years, but in more recent years, the last 20 to 30 years, it's become a much higher focus on OVI cases. Basically what the law says is nobody should operate a motor vehicle under the influence of alcohol or drugs of abuse. That's a law that has several subsections. There is a general section for driving impaired where there is no additional evidence other than the driving and maybe observations of the defendant. There are what we call per se violations, which prohibit a certain level of alcohol in your blood, breath, or urine. And in a per se case, the only thing that has to be proven is that the person was operating the motor vehicle and that their blood alcohol, breath alcohol, or urine alcohol content was in excess of that prescribed limit. DUI is one of a minority of types of cases where there are actually mandatory penalties. There are mandatory minimum penalties which progress from first offenses to second offenses to third offenses, mandatory minimum fines which progress likewise, and also mandatory minimum driver's license suspensions. As Mr. Kourtjohn alluded to in his introductory remarks, eventually these cases leave the municipal court and become felonies if somebody gets a fourth conviction in a 6-year period or a fifth conviction in a 20-year period. And then those are dealt with in the common police courts.
And as we go along, we'll talk about the role of the judge and the numbers of cases that you have out in Kettering, which is one of the busiest courts, not only in the county, I think, but in the state, isn't it?
Well, I wouldn't want to make that claim, not knowing what other courts are
you
doing
don't get a
these
prize
days,
for
but
it.
yeah, we don't get a prize for that.
Yeah.
But we do handle a substantial number of cases and also a substantial number of OVI cases. Actually, we were discussing this a little before the show tonight. DUIs are down in our court this year. I think they're down everywhere a little bit. And maybe that's a product of better enforcement. Maybe it's a product of people getting the message. Certainly the younger generation has discovered Uber and alternative means of transportation to get home from bars and nightclubs and things, which is a good thing. Our court handles, in 2014 we had 706 OVI charges filed. 2015 it was down to 588, and this year we're going to probably come in right at about 500.
That's still a lot.
Still a lot.
It's a lot. It's at least one or more a day.
Yes.
Okay. All right. So these cases get started out on the road. Obviously, people are stopped by law enforcement, and then the next place they go is to the prosecutor's office. So what happens there, Matt?
Well, Mike, when I get an OVI case first dropped onto my desk, I'm looking at a number of things. Probably the thing that I'm looking at first and foremost is the person's past record, because like Judge Dressel mentioned, it does become more progressive. The penalties for OVI become more progressive as the case goes on. I will also be looking at a number of factors basically to help me determine how I'm going to go forward with the case. Am I going to make a plea offer to this particular defendant or not? What is the strength of my case, and what kind of a sentence am I looking at? if this person is ultimately convicted of an OVI.
Well, the judge talked about per se violations where you take a breath test and the result tells the tale, but often there are other things that you are looking for to bolster your case in case that perhaps is one of the weaker parts.
Sure. And we also do get a lot of cases where people just simply refuse to take a test. So we will go forward at that point with evidence of visible impairment. The person is showing signs, just by watching them, how they walk, how they talk, how they perform on field sobriety tests. Those are more challenging cases, but in those situations we're looking at all the facts as far as what we need to be able to prove the OVI case.
One of the things that's come up nationally, you see it on TV every day almost, is that there's a video of by the officer of maybe what happens in a crime or in a traffic offense. Does Dayton use those? Should people be aware of those if they are stopped on the road?
Every jurisdiction has different policies as to how they videotape or whether they videotape a traffic stop. I can tell you the Dayton Police Department and all of their cruisers are outfitted with cruiser video. There are other jurisdictions that will all wear the cameras that fix to their uniforms. Body cams is what they call those. We're getting camera video footage in most of the cases that we prosecute, and it is almost always helpful because it not only helps you to prosecute the cases that are true OVIs and the person was truly impaired, but it kind of helps you weed out some of the cases that may not be as strong.
It's a good resolution tool also.
Absolutely.
Okay. All right. So, Charlie, you're sitting over in your office 7:30 in the morning, and the phone rings, and it's a person with a DUI. What are your expectations?
Well, I try to give them an education first. When they come into the office, the first thing I do is tell them what the process is. A lot of times, the biggest fear is not knowing what happens next. So we walk them through the entirety of the case from beginning to end. Then we go through and we specifically break down how they were arrested and how that fits into the typical OVI investigation. We look at why they were stopped in the first place. We look at the interactions between the officer and between the defendant at the time they were in the car, why the officer removed them from the car, and ultimately we look at how the officer performed the field sobriety test, and that's a distinction. We look at how the officer performed on the field sobriety test, not just the defendant.
Are there expectations that potential clients have before they hire you? Obviously, they have been stopped, maybe spend a night in jail before bonding out, maybe released, and they have a court date, probably, either before or after they talk to you. What do you find are their expectations, and how do those expectations meet what you actually tell them is going to happen, or suggest what's
it
going
runs
to
the
happen?
gamut. Many people come in feeling as though, they're in despair. Many people feel that they're not going to be able to handle this, and they want to have reassurance. Other people come in feeling like this is no big deal. I want to make sure that this just goes away and get done with this quickly. So we try to tell them what exactly the OVI statute says, and a lot of time that means explaining the mandatory penalties and making them see both the people that think that this is no big deal, that this very much is, and the people who feel like this is total, utter despair, that there will be light at the end of the tunnel. I mean, we try to give them a fair appraisal of what's going to happen and how we can help them through that process.
Okay, thank you. Take just a second here to let our viewing audience know that you're watching You and the Law. As you can see, well, you can't see it now, you can just see me. But we're talking about DUI with Judge Fredrick Dressel of the Kettering Municipal Court, Mr. Charles Rowland, a defense attorney in the tri-state area, and Mr. Matt Kourtjohn, who is prosecutor for the city of Dayton. And this is a call-in show. If you want to call in, and our number is 223-5311, and if we could put that up on the screen so our viewers don't have to memorize it, I guess, as much. There you go. So if you have a question about DUI, these three men could answer it for sure. You could try and stump them if you want, but I don't think you will.
It's not encouraged.
Have you ever been stumped on these, Judge?
Probably.
Probably so. Okay. First appearance for a person charged with DUI, they come to court. What is the court's role at this point and then going forward with the person?
First thing you do, like you would do with any criminal charge or traffic charge, is you follow Criminal Rule 5 and you tell the person what they're charged with, what their rights are as far as right to have a trial, right to have their case proven beyond a reasonable doubt before they could be convicted, right to remain silent. If it's a case, as DUI always is, that carries the potential for jail, their right to be represented by counsel, and that if they are unable to afford counsel, that they have a right to court-appointed counsel. And then it kind of runs a gamut, as Charlie was saying. Sometimes they're out, sometimes, as you said, they've spent the night in jail because they've been arrested in the wee hours, and they're coming before me, oftentimes via video arraignment from the jail.
In that case, you're intending to set some sort of a reasonable
right, so
bond
then we would be
them.
setting a bond. Obviously, if somebody is appearing in court, they've already either been released or have posted a bond, a scheduled bond. So the most important thing, we want to convey that this is a serious matter and that they do want to obtain the services of counsel.
Now, some people, if they haven't been through the system before, and maybe it's a first DUI, and of course when you go out drinking, you don't intend to wind up in court. You intend to have a good time and go home, I would think. Do people feel as though they need to tell you their story at that first thing, or is it incumbent to make sure that they do hire qualified counsel for this?
There are times and places, Mike, where confession is good for the soul, but your arraignment on a DUI charge is not one of them. So I will politely tell them that they should probably wait until they talk to their attorney about things and not make statements about the case, and that the purpose of the arraignment is to just give them the information that they're receiving and not to resolve the case at that point.
And probably not take pleas of guilty at the first time.
No.
Okay.
Particularly in a case like OVI, where if you are convicted and God forbid you have a future incident, that incident could and would be enhanced by your previous conviction.
All right. Now, the judge's role doesn't end there, and I won't ask you everything else you do right now, but you don't follow the case until it next comes into court, probably for what hearing?
Well, just briefly, what usually happens once an arraignment's completed, sometimes we'll continue it if somebody intends to retain counsel. We'll appoint the public defender, and then once counsel is involved, a pretrial conference is set, which in our court would include me as the judge, the prosecuting attorney, the defense attorney, to explore where the case will head from there, whether it's headed for a motion hearing, perhaps in certain cases when the discovery is completed, if it's completed at the pretrial, it may result in a resolution on that date.
Okay. All right. So, Matt, on the prosecution end, you've reviewed the file when it first comes in. Do you talk to the officers then, or do you wait for a pretrial, and is that the next point that you get involved with the case?
In most cases, hopefully the officer has given me enough information about his case through his reports and then through any video that he might have that I'm not going to have a whole lot of discussion with the officer before the pretrial. There are situations where I might be looking at my file and see that there's some important bit of evidence that I know should be there but isn't, so I'm going to contact the officer in that case. But my goal is to have all of the information for myself by the time we come to the pretrial. regarding the case, and to also give all the information that I have over to Charlie to make sure that he can come to the pretrial prepared and have him know just as much about my case as I do.
Do the defendants or defense attorneys generally come down and get reports from you, or is this something provided later on at a pretrial?
Well, our office policy has always been to have open discovery, and I think that's actually mandated by our criminal rules at this point. Generally, discovery will be requested through a discovery demand that's filed by the defense attorney. Mm-hmm. For attorneys that I work with fairly regularly, like Mr. Rowland here, I've got his email address almost memorized, so I know what he wants to see, so I'm going to be scanning as much as I can and just emailing it as soon as I see that he's on the case.
Okay. All right. So, Charlie, you're on the case. Let's assume you're on the case for the purpose of our discussion here. You know a little bit about it from what the person has told you, and now you've gotten reports and discovery from the prosecutor's office, whether it's Dayton. And I assume that you practice, when I said tri-state area, was that accurate?
I have gun will travel. I go all over the state.
All
yeah.
right, all right. You're not Richard Boone, but close enough.
Yeah.
So what do you do then?
I think the most important part of a pretrial from my perspective is to try to have the prosecutor look at the case through my eyes. When they open that file, there's everything bad written down that the police officer wants to say. But if you can have a good discussion with the prosecutor and say, here are the issues, and it's a lot like walking through the forest with someone who really knows the forest. You're going to have a much richer experience because they know more about the forest than you do. When you hire a good attorney, they're going to know, they're going to see the issues, and they're going to be able to go to the pretrial and have a conversation with the prosecuting attorney. And a lot of people think that we're adversaries all the time. We're not. We're working together to reach a resolution. And the issues that we bring up are issues that we're going to talk about. And yes, sometimes they have to be litigated, but it's a lot more collaborative than you would think.
Okay. I understand from our floor director that we have a call on line 1, so we'll take that call at this time. Good evening. You're on You and the Law.
Hi. Thank you for taking my call.
Yes.
I work late, so I'm often coming home after midnight, sometimes as late as 2:30, 3 in the morning. And oftentimes, especially on the highway, I encounter drunk drivers. And I've been fortunate that I've had no incidences, but I was wondering if there is something I can do as a driver to report that or stop it or somehow, or report it to authorities. I don't know how to do that, if it's possible.
All right. Excellent question. And what's the answer to that? Or is there an answer?
There are a number of answers. The first is you can call law enforcement via 911, and the second is the state has established a number called 1-800-GRAB DUI. I believe that's the right one, and you can call that number as well. But be careful. That may be just some distraction. They may be texting. It may be a phone call. There may be any number of reasons why someone is driving erratically, and to make that allegation is a pretty big one.
Okay.
It's also important to know that when you call that number, you can remain anonymous if you want to, although if you are willing to give more information to the dispatcher, we would encourage that. The more information they get, the easier it is to kind of rule out some of those cases that might not be drunk driving related. But what I like about the GRAB DUI number is that it is an opportunity for an officer to investigate. They may, find out that it is a medical issue, which is, just as important to, help that person as it is to get a drunk driver off the road. But it's just the beginning to, for the officer to start his investigation, assuming that phone call results in a contact with the driver.
How likely is it that there would be, okay, let's assume that the driver, our caller, would call in to one of those things, and they may have to text or use their phone, I guess, at the same time, that the officer would be able to find this miscreant out on the road. Or would they already be gone? Obviously, everybody's mobile here.
I think our officers do a good job interacting with citizens and knowing where they are on the road, and I think it's often the case that they're able to find people who are reported as drunk drivers.
Or erratic drivers is probably what they're reporting, not knowing whether they're drunk. Maybe they don't even know until they get to court whether that's the case.
We can't assume someone is drunk. There are a number of reasons someone may appear impaired, but it's certainly not right to assume that someone is intoxicated just by how they're driving alone.
Do we know if there's any statistics on these call-ins on the grab DUI or the 911?
I'm not aware of any statistics that show that they're working to get people off the road or not. Probably want to have a trooper in here to answer that question.
Okay, next year.
I think I would just say to the caller, better safe than sorry. You know, if you're driving down the highway, and we've all had it happen, it's late at night and somebody's straddling lanes or driving very erratically, you know, whether or not they're under the influence of alcohol, it is worth having an officer investigate further. So I would encourage you to take advantage of those lines, yes.
Yeah, okay. Does that answer your call?
Yeah, is the grab DUI number, is that a nationwide number, or is that just Ohio?
Grab DUI?
I think that one's Ohio.
I think it's Ohio Department of Public Safety that runs that.
Right.
Yeah, and there might be information Googling on the further than what we've given you. Do you have any follow-up or anything?
Well, I do, and your guest made a good point about not assuming somebody's drunk. But as a driver, and if I were to call, you know, what things would point to drunk driving as opposed to being maybe distracted or just, you know, something like that?
The National Highway Traffic Safety Administration has actually come up with a guide that officers are given. There are 24 clues of impairment, cues of impairment that they look for when someone is driving. Speed is not one of them. So often we see someone stop for speeding, but there are obvious things that you would look for and obvious things that a good officer is going to look for when he comes upon someone on the highway.
Maybe slow speed.
Slow speed is...
slow speed.
Slow speed would be one indicator,
right.
And that would be a point of litigation.
Yeah, okay.
To another driver, drunk driving and distracted driving, whether it's texting or whatever, might look exactly the same. So I would say don't worry about whether what you're seeing on the road is drunk driving versus distracted driving versus you know, somebody's sending an email or eating while they're driving or whatever. If you see somebody on the road that is driving erratically, is driving dangerously, call the number and allow an officer to investigate.
And they're not going to be called as a witness anyway. They're just alerting law enforcement that there could be a problem, and the law enforcement would be responsible for gathering evidence, I guess, of impaired driving.
Right. And in fact, law enforcement, if the person does call and they remain anonymous, is kind of required to corroborate or verify what's been told to them by the caller before they even pull the person over, so that, you know, if the officer gets a call saying, you know, this certain type of car out on I-75 is driving erratically, and the officer comes up with this or comes in contact with this car, generally they're going to follow for a while to make sure that what they're seeing is consistent with what was on the call. They're not just going to immediately pull the person over.
Okay. All right. Does that answer your call or your question from your call?
Thank you.
All right. Thank you.
Bye.
Floor director tells us we have a call on line 2, so we'll take that one. Good evening. You're on You and the Law. Hello.
Hi, this is Crystal calling from Philadelphia, Pennsylvania. Thanks for taking my call.
Good evening, Crystal.
So I have a question about whether, I've heard this somewhere, but I don't know if it's true. Do I have criminal liability if I'm not the driver myself, but if I fail to stop somebody from going out drunk driving? For instance, if I throw a party and there's somebody at the party who gets intoxicated, and I know that they shouldn't be driving, but I let them drive anyway. Is there any sort of third-party liability of that sort or another scenario like that?
Well, that's a good question.
Yes,
Judge?
there can be, and it may or may not be criminal. It may be civil. There's a different standard of negligence. You know, that's you didn't exercise the duty of due care, and that's generally a civil law concept. Now, if you actually know somebody's intoxicated and you hand them the keys to your car, that would be a criminal offense of wrongful entrustment. So yeah, it's always good to have a contingency plan when you're entertaining, whether it's somebody who's going to drive your guest home, a shuttle to a hotel if it's a family event like a wedding or something where people may be at a reception, and particularly they're in an area where they may not be familiar with the surroundings, and you know, it's hard to sometimes say no to that last drink when you haven't seen your relatives for a few years, but have a contingency plan for these social events, because as much as one might want to empathize with somebody who makes that mistake, the law doesn't really allow that. That's not an excuse.
In fact, wrongful entrustment is an offense in Ohio that not only after one or two convictions can result in some pretty serious jail time, but can also result in the forfeiture of your vehicle if you allow somebody under the influence to operate a motor vehicle, or your own motor vehicle.
Right.
All right. Crystal, does that answer your question?
It does. I guess I'm just wondering what you do if the person doesn't want to either stay or let someone else drive them. I mean, would that be a defense if you say, well, I tried and they refused to, turn over their keys or let someone else drive them?
It's going to always depend on the particular facts of a particular incident. There's not one set answer for all, but the better practice would always be to stop them.
Yeah,
And if you have to, I mean, you don't want to call law enforcement on a friend, but much like if you had a fight with a spouse or a significant other and they were going violent, you would call the police to defuse the situation, and that may be what it takes, because believe me, your friend will thank you profusely if he avoids being in an OVI situation, or worse yet, a vehicular homicide situation, because him or her driving results in an accident and serious harm or death to somebody.
Yeah, and if that happens, they're going to sue everybody in the chain
Right.
along the line, so you might think you're okay and you might still be involved.
Right.
And, before we were talking about a concept which is newer, probably in the last 10 years or so, is call an Uber driver.
Yeah. And that is very, very popular with younger, and people younger than I, but I mean, I have 3 just out of college age children that Uber is a way of life for them and their friends. There's the old have a designated driver that's truly a designated driver, somebody who's not drinking alcohol at all, as opposed to somebody who's drinking 3 or 4 instead of 7 or 8. But you can plan ahead, and if you do plan ahead, you really minimize the likelihood of those situations occurring. Not that they can't occur, but it's worth thinking ahead when you know you're going to be out in public socializing or hosting an event at your home where people will be drinking, and just take that extra degree of caution and care.
All right. Does that answer your question, Crystal?
It does. Thank you very much.
Are we streaming okay in Philadelphia?
It's streaming now. It was down for a while, but it's back up.
Okay. Thank you for your call.
Thanks.
All right. We're going to take a very short break here. We don't have any commercials on You and the Law, so we do talk about the Dayton Bar Association, which sponsors our program, and some interesting facts about the Dayton Bar Association. Challenge me if I'm wrong, gentlemen, but it began in 1883 here in the Dayton, Montgomery County area. And our mayor was John Miller at the time, and our city solicitor was A.W. Cumler. We see his name on a lot of buildings, Cumler buildings. And President Chester A. Arthur, who used to run the New York Port Authority, was the President of the United States at that time. So Dayton Bar Association's been around a long time. Our director is Bill Wheeler, and he told me to tell you about some of the programs. And they are a lawyer referral service. If you don't have a lawyer, you can call 222-6102, and somebody at the Dayton Bar Association will find out what your case is about and refer you to somebody who, when I say somebody, I mean an attorney who knows something about that area and will help you along if you want. We have a notary public service. If you want to become a notary, if you belong to a company that requires a notary, we have applications and testing, and you can become a notary, and everybody in your neighborhood will want you to sign their car titles when they sell them. Wills for Heroes. Judge, they have had some of those out in Kettering, haven't they? Where volunteer members create wills for emergency first responders, firefighters, police, and EMTs. A worthwhile project, and if you fall into that category, you should go and do it. We have a number of community service projects. Our website is www.daybar.org, and we also sponsor the Volunteer Lawyers Project, which serves the disadvantages and founded and supported by members of the association. So we're proud to have them sponsor us, and we hope they keep doing it. Okay, we're talking about DUI, and we have a call on line 1, and we're going to take it. Good evening, you're on You and the Law.
Hi, I have a question for you about breathalyzer tests.
All right.
And sobriety tests. I was wondering if you take one of those and it shows up negative, but they make you do the walking the line or saying the alphabet backwards and you can't do it, can they still get you for a DUI?
I think we were
Yes.
talking about that before, and I'm not sure is there a negative test, Charles?
No. When an officer arrives on scene, he's not looking to exclude, he's looking to include clues of impairment.
Okay.
And he has to make the decision to arrest before he has a breathalyzer test. So often the officer, he or she will use the standardized field sobriety tests.
Do you have to take those?
No, you don't. There's no obligation for you to take those, but under certain circumstances, if you have a CDL, you're underage, or you have a prior, the law does require you to take the breathalyzer.
Tell us what a CDL is.
A commercial driver's license.
All right.
All those people out there on the road earning a living, going up and down the highways that have a special license that allows them to do commercial driving.
Okay. And, all right, so the officer stops a person and they attempt to get them to do field sobriety tests.
There are 3 standard ones.
All right.
The first is the testing of your eyes. It's called the horizontal gaze and nystagmus test, which is a mouthful. But what they're looking for is a fluttering or a bouncing of the eyeball. The next involves a walk and turn, where you walk 9 steps under very strict directions, turn around and walk 9 steps back. And the last standardized test, only in conditions of alcohol, we're not talking about marijuana now, but in conditions of alcohol, is the standing on one leg test, where the officer gives you very specific instructions and you're required to stand on one leg for 30 seconds.
Sounds hard.
It is hard, and it's very difficult at roadside. It's very difficult when you're scared. It's hard to listen to all those instructions. And I always like to point out that those tests were designed on 20-year-old Navy SEALs, which I don't think I could compete with a Navy SEAL standing on one leg or much else at this point. But they are hard tests, and the officer's not looking for reasons that you are not intoxicated. The officer's looking for reasons that you are intoxicated.
All right, let's think of 2 scenarios here following the caller's question. 1, you don't take these tests, and 2, you do, and I don't think I've ever seen one where somebody doesn't they call them clues, but goofing up on something happens. So let's say they say, I'm not going to take any of your tests. Then what?
It puts the officer in the position of saying, do I have enough evidence? Do I have probable cause to place this person under arrest? And an officer's observation, these are good guys out on the roads. These are good officers who have good common sense, and they know a lot, and they're not going to make a mistake. But it gives them a lot less evidence to work with when you don't take the field sobriety tests and you say, no, you're going to have to make that decision based on what you have before you right now.
And at what point will an officer be able to say, I think that you should be taking some sort of breath or blood test and maybe suspending your license?
An officer reaches a determination of probable cause. He uses all of the totality of the circumstances, how you were driving, how you interacted with him when you were him or her when you were inside the car, and finally how you perform on the field sobriety test, your overall attitude. All of those things are taken into account, and if the officer reaches a determination that it's more probable than not, pretty easy standard to get to in your mind, if it's more probable than not that he feels or she feels that you are intoxicated, they're going to place you under arrest for OVI.
Okay, so if the person doesn't take any of the tests, it's still a possibility and maybe even a probability to maybe arrest them and say, I think you ought to be taking the test.
If the officer reaches a probable cause determination, the next thing he or she will ask you to do is they will take you to the station and ask you to conduct a chemical test, yes.
All right, and conversely, if they do take the tests out on the road that you described, what next after that then?
The officer can either say, I have not reached a probable cause determination and you're free to go, or the officer will say, you're under arrest, come with me and we're going to take a breathalyzer, urine test, or a blood test.
Okay, so back at the station, let's say they're back at the station, do you think, based on the experience you've had doing this over the years, that more people that are stopped initially wind up being arrested and back at the station than let go?
I think that what we have to realize and what we have to look at is the training of the officer.
Right.
They're trained that DUI is one of the most arrested offenses, that people do it a lot. And they're also trained that when you make a stop, that these clues and these ways that they're given to look at these cases almost lead them to look for reasons that you are, not reasons that you're not. It makes it different. But again, you get a good officer in a good circumstance, I think everybody at this table knows that they're out there making good decisions.
Okay. So your client is back at the station. You don't know they're your client yet unless they've called you from the road. And
which happens.
If you take the test, what happens? And if you don't take the test, and you have the option, if you don't take the test, what happens?
Well, this is one of those ethical things for attorneys. If you are underage, if you have a CDL, or if you have a prior offense, an attorney can't tell you not to take the test.
No, I'm talking about the person
For the
themselves.
other type of people, you have to decide, is it in my interest to give them evidence or is it not? There are penalties associated with it. For instance, on a first offense, and the judge will tell you, we will, under the implied consent doctrine, take your license away for 15 days if you take the chemical test, or we will take it away for 30 days.
On a first offense.
On a first offense. 30 days, you will not have driving privileges if you refuse the test. So those are the penalties that people are given. And the officer has to, by law, read them, these penalties, before they make that decision. That's under what is called the Administrative License Suspension, or the ALS.
And if you do take the test, there are certain levels that you could also be suspended.
Yes, there are two tiers under Ohio OVI law. The first is a .08, which is the standard for all drivers, not juveniles, not truck drivers, but just all citizens, is a .08 standard. If it goes above a .17, that's what we call sometimes a super OVI or a high tier OVI, and that person is subject to double penalties, essentially, under the law, which are mandatory penalties on a first offense, and they get subsequently worse as you get more.
All right. turning back to our caller, unless you all have a...
I
Judge,
would
did you have
make just
another
one more
comment?
point that Mr. Rowland was saying about on the refusal situation versus the consenting situation. If you refuse the test, you will lose your license for 1 year on the first offense. When he alludes to 30 days, that's 30 days which you can't drive at all. The court does not have authority to let you drive to and from work, which can be very difficult for some people. If you take the test and test over, you will lose your license for 90 days, but the court can give you privileges after 15 days. I just want to make sure you didn't think that a refusal means I'm only without a license for 30 days. You're without it for a year.
So there's some choice to make there, whether you want to be suspended for a year and not give evidence against yourself, or maybe get privileges sooner if you think maybe you're a little over the limit.
Well, I'll mention there's also a third outcome. You can
Okay.
take the test and be below the test,
And then,
no license suspension at all.
right.
Right. We never think of that, I
No,
guess.
I never thought
It
that.
doesn't.
So, all right. Okay, now we'll turn back to our caller. Does that answer your question?
It does, thank you.
Do you have any follow-up?
When you said there was automatic driving loss if you refuse to take the breathalyzer, are there any automatic penalties for refusing the sobriety test, or it's just that they'll take you automatically to do breathalyzer or blood?
Go ahead.
There I think the question, I want to make sure I understand the question. The question was, are there any automatic penalties if you refuse to take the field sobriety tests?
Yeah.
Okay. Generally, no, there are not. I will say this, most good officers are going to be using the field sobriety tests as a screening tool. And I think that I will probably disagree a little bit with some of what Charlie was saying here a moment ago, that it's only a test of inclusion. A lot of officers will use the field sobriety test to screen out people that are not under the influence. And a lot of officers that you talk to will tell you that they use the term cut people loose. They cut just as many people loose after performing well on field sobriety tests as they may arrest for people that don't do well on field sobriety tests. So, you know, there can be an advantage to taking the field sobriety test, because you may help the officer screen out, well, you aren't in fact under the influence. Whatever it was that I saw at the outset of the traffic stop, turns out I was wrong, you did well on the field sobriety test, and we're going to let you go.
Okay. Does that answer your question?
Yes, thank you.
Okay, thank you for your call. All right. Judge, one of the things that we wanted to, and of course, we're talking about prosecution of DUIs, defense of DUIs, what can happen and things like that. Part of DUI problem, of course, is, you know, it's dangerous, and people could kill themselves and other people, and maybe they don't take it seriously enough. So do the courts provide programs, and of course we would ask the attorneys also if those are things that they discuss with their clients for rehabilitation and getting them so they're not drinking and driving and endangering lives?
That's a really good question, Mike, and I would say that is all of us know at this table that whenever there's a new law regarding OVI, it's to make things tougher and not easier. We've talked about the fact that there are mandatory penalties, and on a first offense, there is a mandatory penalty of 3 days in jail. There is a exception, if you will, that the law allows the court to have a defendant on a first-time OVI attend a 3-day intervention program, so long as that intervention program is residential. And generally those are held at area hotels or conference centers. The purpose being that if they complete the program, you're assessing them, you're diagnosing, was this just an isolated incident, or is there maybe a person here that's on the cusp of having a drinking problem, and you're doing some education and assessment, and at the same time you're fulfilling the requirement that somebody, quote, serve 3 days. So on the first offense, most courts tend to approach it in a little less punitive way by giving somebody that option and hopefully stopping this from happening again with that particular individual. We will generally allow somebody to do that residential program, and then we will get a report, and that report will include an assessment of the defendant, whether they believe that the person should or would benefit from additional counseling. And generally, if they do recommend additional counseling, part of the sentence that I construct will involve a requirement that they complete that. And there will be an incentive to do that, in that if somebody does not follow through with that condition of probation, the court can impose up to 6 months in jail on a first-time OVI. Fortunately, I hardly ever had to do that, but the focus on the first time around is generally trying to divert this person from drinking and driving ever again, and to give them at least an opportunity at some education.
And are there statistics that indicate whether these things are working?
I think, as we were talking before we came to the air, I don't have chapter and verse here, but I think Mr. Rowland was saying it's 87% will not be back. And that's a pretty good number. We try to work with, if somebody does get a second one, we have a fairly intensive probation that after serving their minimum required or maybe a little more jail time, that we have them supervised pretty closely by a probation officer. We may require them, there's some technology that allows us to detect whether somebody's using alcohol. It's called SCRAM. It's a bracelet that measures alcohol through the pores of somebody's skin. And you can also use that same technology to put somebody on essentially house arrest. So it's got a GPS feature so that you can, maybe without having them in jail, still have some restriction and control over their behavior.
Now, when you say a second, you're talking about a second within the 6-year period, or just a second overall, like if you got one in 1992 or something?
I think the important thing to remember is the court always has jurisdiction to impose up to 6 months in jail on either a first or second offense. The court must impose 3 days on the first, with that caveat that it can also be done as an intervention program. On a second offense, there is no such thing as an intervention program. By law, the court has to impose 10 consecutive days in jail. So that is something that, again, education on the front end is far better than finding out the hard way.
Yeah. And I was going to say, with the prosecution and defense, we're trying to prosecute people who are breaking the law, and on defense, we're trying to find reasons why maybe the prosecution doesn't hold. But do we all hold some sort of responsibility to these folks to find their way into rehabilitating themselves, whether they're being prosecuted to the full extent of the law, or maybe getting through a loophole and getting out?
I know, as a prosecutor, if there is a chance to rehabilitate somebody, and if there's a chance to reduce the chance that they're going to be under the influence and behind the wheel again, I would like to take that opportunity to explore whatever option that might be. The statistic that always sticks out in my mind is that 50% of fatal automobile accidents involve alcohol, and one or the other drivers, somebody's been consuming alcohol. So obviously, we don't pick OVI and make OVI laws more stringent just because that was the one that we decided we were going to make more severe. There are true consequences to people driving under the influence of alcohol, and obviously, fatal accidents are what we're trying to avoid. Now, when we're seeing people that are coming in on a second offense, a third offense, a fourth offense, ever, or especially within 6 years, at that point, it's probably more in my interest as a prosecutor to be protecting society, because I think we've probably given this person a chance to rehabilitate at this point. They've not taken that opportunity, and now I need to be protecting the public and drivers from this person.
Charles, thoughts?
I think I do have an obligation when someone hires me to at least force them to once question their relationship with alcohol, I'm very proud of the fact that I've served on boards where we have access to treatment. People come into my office all the time and they leave having received treatment. It's something fundamental that we all share at the table, we all share with the law enforcement officers, is that we don't want anyone ever to go out and hurt themselves or someone else. You hire me and I'm going to do my darndest to make sure that you don't have an OVI on your record. But you also hire me and I'm going to do my darndest to make sure you never get in that situation ever again, that you think it through, that you Uber. I've even offered to come, pick people up who've called me and said, well, I might as well just drive home.
There's dedication.
Well, that's how we all should be, and I know these guys are dedicated that way, and I know, law enforcement officers are. So yes, I do think we all have an obligation, and if we do our jobs right, we're not going to have people come back and either hurt themselves or someone else or come back with an OVI.
Great. Our floor director tells us we're running out of show here, so we're going to call a halt for now and let you know that this has been a production of You and the Law here at the studios of DATV. We've been talking about DUI, and I want to especially thank our guests, the Honorable Fred Dressel from Kettering Municipal Court. Thank you for being here. Mr. Matt Kourtjohn, Assistant Prosecutor for the City of Dayton, and Charlie Rowland for giving up time working on DUIs to come and talk to us and the viewing public. I want to thank all the volunteers behind the scenes who've made this program possible. Special shout out to Lily and Katie, and have a happy holiday. If you're having a great time and you're drinking, try not to drive. Have somebody else do it. Call an Uber. Stay safe. See you again on You and the Law. Good night.
Thank you.